Welcome back to the deep dive. This is where we really dig into the tough stuff, the complex source material, and pull out the absolute must-know actionable insights you need. Today, we're tackling something that honestly should be right at the top of everyone's financial checklist, estate planning. Specifically, the urgency around it. And we're putting a real spotlight on the unique, sometimes confusing legal world of Florida. So our mission for this deep dive is really clear. We want to cut through the noise, the general advice, and zero in on the technical know-how you need. We need to understand why getting this done now is so critical and exactly how Florida's specific laws just raise the stakes incredibly high, basically inaction in Florida. It's not just procrastination, it's a measurable, potentially huge financial risk. We're aiming to give you the expert's view, the blueprint for protection, drawn straight from the legal and financial strategies in our sources.
Yeah, and it's important to say this isn't just, dry legal theory. Okay, yes, there are legal documents involved, but the core ideas we're pulling out today, they're incredibly practical. It's all about showing you how to keep control over the assets you've worked hard for, and maybe most importantly, how to shield your family from all that extra administrative hassle, financial drain, and frankly, emotional stress. This dive is about using knowledge to really lock down your security.
Okay, to really set the stage and hammer home that urgency right from the start, we absolutely have to kick off with this central kind of shocking statistic from our materials. Are you ready for this?
Yeah.
76%. 76% of Americans do not have an estate plan.
76.
Yeah.
It's a staggering number, isn't it? And it immediately points to this huge gap, this critical failure point in how Americans manage their finances. When you have, the vast majority, three-quarters of the population failing to plan, what does that actually mean? It means three-quarters of families are basically leaving the future of their wealth, the security of their kids or dependents, the financial stability of whoever survives them. They're leaving it completely up to chance. They're effectively handing over control to the state government.
And when you say handing control to the state, we really need to drive home what that translates to in reality. It's not just like an inconvenience. It means you're letting this rigid, totally impersonal, pre-written government formula, they call it the law of intestacy, dictate what happens after a lifetime of work and saving. And that formula, as we're about to see, it's rarely, if ever, really equipped to deal with, the complexities of a modern family.
Precisely. The state's formula, it's fixed. It can't possibly account for nuance or complexity. It just looks at relationships based on strict legal definitions. It doesn't know about, say, a blended family situation, or a domestic partner who isn't legally married, or that special needs trust you really wanted to set up for someone, or even just that specific piece of property you promised your niece. It just operates mechanically, almost like a machine. And that, right there, is the definition of creating financial friction and a lot of emotional pain, too.
Okay. Let's dive straight into analyzing the tangible consequences for you, the listener, if you happen to be in that 76% right now without a plan.
Right.
Our sources really break these down into three main buckets.
Yeah.
How the state distributes things, the potential for family conflict, and these costly administrative processes.
Right. So first, if there's no plan, the state decides who gets your assets. This is through those intestacy laws we mentioned. Now, they vary a little bit state by state, but the basic structure is usually this pretty rigid hierarchy. If you have a spouse and kids, it often gets split between them in fixed percentages. If you're single, it typically goes to parents, then out to siblings, and so on down the line.
Okay.
But here's where that lack of planning can become truly disastrous, especially with modern family setups. Think about an unmarried couple. Maybe they've lived together for 20 years, raised kids together, but maybe most of the assets, the house, the accounts, are legally just in one partner's name. In almost every state, intestacy law completely ignores the surviving partner who wasn't legally married. It's as if they don't exist in the eyes of that law. So the deceased partner's assets, they'll pass directly to their blood relatives, could be children, parents, even distant siblings, leaving the surviving partner potentially with no automatic right to the home they shared or joint accounts or anything really, unless they can mount a very difficult and very expensive legal challenge.
Wow. That's a potential catastrophe. A profound injustice, really, built entirely on maybe a conscious choice not to have that legal marriage structure.
Yeah.
The state's formula, it's just inherently blind to those kinds of modern relationships.
Absolutely blind. And that lack of considering the actual personal context, the reality of people's lives, leads directly into the second major consequence the sources point out. These absolute devastating family disputes, when the state's fixed division, overrides what everyone thought was going to happen, or when it's just unclear who gets what specific asset, conflicts is almost guaranteed.
Yeah, you can just picture it. It's that terrible intersection of deep grief and suddenly high financial stakes. Like, was the family business really meant to go to the daughter who's been running it day in, day out? Or is the state now going to force an equal split among, say, 4 siblings, where maybe 3 of them have zero connection to that business? That ambiguity, it just acts like fuel on the fire for resentment, doesn't it? Leading to potentially years of fighting in court, which often just destroys family relationships completely.
Completely. And the fights often center on this difference between, relative cash value versus deep emotional value. If assets just get liquidated, sold off, okay, the disputes are maybe about percentages of cash. But if the assets are physical things, maybe art, family heirlooms, the house itself, the fight becomes incredibly personal, deeply emotional. The lack of clarity just shatters family cohesion right when they need each other the most. And crucially, all these disputes feed directly into that third, almost universal penalty for not planning, the requirement for these costly probate proceedings.
Probate. That word sounds like the legal hammer that comes down when there's no plan. Can you maybe elaborate a bit? What does probate generally involve, and why, specifically without a plan, does it get so ridiculously expensive and take so long?
Right. Probate is basically the court-supervised process. It's legally required to do a few things. First, prove a will is valid, if one even exists. Then identify and inventory all the assets, pay off any debts and taxes the person owed, and finally distribute whatever's left over. And that distribution follows either the state's intestacy law or the instructions in a valid will. But the key is, without effective planning, or sometimes even if you only have a simple will, your assets have to go through this court process.
Okay, so it's mandatory court involvement.
Mandatory. And the high cost. It comes from several places. First, you've got court filing fees, administrative costs, maybe fees for formally appraising the value of everything in the estate. Second, and this is usually the biggest chunk, are the fees for the lawyers and the person the court appoints to manage things, the personal representative or executor. They have to get paid for all the time spent navigating this, frankly, bureaucratic maze. In many places, just the standard attorney fees for a typical probate can easily eat up anywhere from, say, 3 to 7% of the total gross value of the estate, not just the net value after debts.
Wait, 3 to 7% of the gross. So if you have, let's say, $1 million estate, you could be looking at potentially $70,000 vanishing just into administrative costs, money that doesn't go to the family.
Yeah, exactly. $70,000 or more, right off the top, reducing the inheritance. And that's assuming it's a relatively smooth probate. The time factor makes it even worse, and time equals more cost. If the estate is complex, if there are disputes, if there are significant debts, probate can easily drag on for, 18 months, 2 years, sometimes even longer if there's actual litigation involved. And during all that time, the family often has very limited, if any, access to the funds or the assets they might desperately need. Now, in Florida specifically, we see this distinction. There's formal administration, which is generally required for larger estates or ones where there are disputes. And then there's summary administration, which is quicker and cheaper, but it's only available if the estate's value is under a certain threshold. Right now, it's $75,000, not counting the value of the main home, the homestead property, or if the person has been deceased for more than 2 years. Without a plan, you are almost certainly going to be pushed into the slower, much more expensive formal administration process.
Okay, that really reframes the cost. It's not just the direct fees, it's the hidden cost of delay hitting families right when they might need liquidity the most, right after losing someone. So basically, without solid planning, the family is forced to pour money into this financial sinkhole, all while being stuck with the state's rigid, one-size-fits-all distribution plan.
That's it, precisely. It's an involuntary process, it's expensive, it's public record, and it completely removes your control.
All right, let's shift gears now and really unpack this within the Florida context, because our sources are crystal clear on this. Those general risks of inaction, they are even higher for anyone who lives in Florida or even just owns property there. Why? What makes Florida so uniquely challenging?
Florida's body of law, it really is, as you said, a dual-edged sword. On one hand, the state offers some huge financial advantages. We'll get into those, and that definitely attracts high net worth folks. But on the other hand, the specific laws that govern how property gets transferred and inherited, especially the homestead protection rules, they are so specific, so restrictive, that if you fail to plan correctly with Florida law in mind, those very laws designed to protect you can actually turn into serious legal roadblocks. They can actively jeopardize the wealth you're trying to pass on and completely override what you personally wanted to happen.
So what you're saying is relying on maybe a standard boilerplate estate plan that was drafted somewhere else, say Ohio or Michigan, even if it's technically a valid will, it's not just risky in Florida. It's almost negligent. Because it won't address those specific Florida hurdles. It sounds like Florida absolutely demands specialized planning built right into the documents themselves.
That's the absolute crucial takeaway. You need documents that are specifically designed to comply with Florida's unique rules. If you ignore those unique restrictions, particularly the ones related to real estate, you run a very real risk of having the state's mandates completely trump your personal wishes. It can turn that potential protection into an unexpected, expensive, and painful legal mess for your family.
Okay, despite those high stakes, that scary 76% number, and the Florida complexities, there is some encouraging news here. The sources suggest that actually starting the process, laying the foundation, is often simpler than you might think. It's about getting the core pieces in place. Now, the source material we looked at mentioned 3 crucial documents, but for the kind of deep dive we're doing, I think we really need to address the 4 pillars that create comprehensive protection, 2 that handle things after death, and 2 absolutely vital ones for managing things if you're incapacitated but still alive.
That's a great way to frame it. We need to systematize this foundation. And you're right, these documents work together to achieve 2 main goals. First, making absolutely sure your wishes are honored regarding how assets get distributed, and second, drastically reducing the stress, the cost, and the delays for your family, mainly by keeping things out of court as much as possible. Hashtag tag 2.1, the will, the foundation for distribution and guardianship. All right, first pillar, the last will and testament, or just the will. This is often the starting point for most people. Its core job is really twofold. First, it clearly states how you want any assets distributed that are titled just in your individual name, the ones that have to go through probate. Second, and this is critical for parents, the will is the only legal document where you can officially nominate who you want to be the guardian for your minor children if something happens to you.
That guardian nomination, that's huge. Probably the most emotionally significant part of a will for any parent, right? Making sure the state doesn't end up deciding who raises your kids.
It's absolutely immense. Now, technically, the court still has the final say, but having that nomination clearly documented in your will, it carries incredible weight. The courts almost always respect the parent's choice, unless there's a very compelling reason not to. It provides enormous peace of mind. Now, shifting back to asset distribution, we need to keep hammering this distinction. A will is essentially a set of instructions for the probate court. It tells the judge who should get what.
Okay, instructions for the court. But what happens if the will is the only planning document someone has? We already kind of touched on this. It dictates the outcome, maybe, but it doesn't necessarily make the process smooth. How exactly does it interact with that costly, time-consuming probate process we talked about?
This is the key point where listeners really need to focus. A will by itself does not avoid probate. In fact, it guarantees probate. For the will to have any legal power to actually transfer an asset from your name to your beneficiary's name, the court must first validate that will. That's the probate process. And that process inherently takes time and costs money. So any assets that are only covered by the will, meaning they aren't jointly owned or in a trust or don't have a specific beneficiary named on the account itself, those assets are effectively frozen. They're stuck until the probate judge gives the official okay for the transfer.
Oh, okay.
So, yes, the will solves the distribution problem. It stops the state's intestacy rules from taking over, but it absolutely does not solve the fundamental problems of the cost of probate, the lengthy time delays, or the fact that it's all a public court record. And that's precisely why, for anyone who really wants to ensure a timely, private, and efficient transfer of assets, the next document becomes absolutely essential. Hashtag tag 2.2, the Revocable Living Trust, the tool for avoiding probate.
Right. Our sources specifically call out the Revocable Living Trust as being crucial for avoiding that unnecessary family stress. It's often presented as the go-to tool for streamlining how assets get transferred. So what makes a trust functionally so much better than just a will when it comes to avoiding all that administrative hassle?
Well, what's really interesting about the trust is the timing. A will is fundamentally a death document. It only kicks in, only has legal effect after you pass away. A revocable living trust, on the other hand, it's an immediate planning tool. You create it, you sign it, and it's legally effective right then and there while you're alive. And here's the crucial part. The trust actually takes legal ownership, takes title to your assets while you're still alive. You then manage those assets, but you do it in your role as the trustee of your own trust.
Okay, so the trust owns the assets, not you personally anymore.
Exactly. And because the trust, which is treated as a separate legal entity, holds the title to those assets, when you pass away, those assets are not considered part of your personal estate that needs to go through probate. They bypass the court's jurisdiction entirely. The person you name to take over, the successor trustee, simply steps into your shoes. They follow the private instructions you laid out in the trust document and distribute the assets usually much more quickly, privately, and without needing court supervision.
That speed and privacy must dramatically cut down on family stress. And presumably it cuts out most of those big administrative fees and attorney costs we discussed earlier with probate. But I know, just from hearing about common planning mistakes, that probably the biggest hurdle with trusts is actually getting them funded, right? What happens if people go through the trouble of setting up a trust but then forget, or just don't get around to actually retitling their bank accounts, their investment portfolios, maybe their house, into the name of the trust? Doesn't that make the trust kind of useless for those assets?
That is, hands down, the most common point of failure, and it's an excellent thing to really dig into on a deep dive like this. You're absolutely right. A trust is essentially just an empty legal box until you put something in it until it's funded. If you draft a beautiful trust document, but forget to change the title on, say, your $500,000 brokerage account from John Doe individual to the John Doe Revocable Living Trust, well, legally, when John Doe dies, he still owns that account individually. And guess what happens then?
It has to go through probate.
Exactly. That specific asset has to go through probate, potentially defeating a major reason for setting up the trust in the first place. Now, to try and mitigate this, because let's face it, it's easy to forget an account or misretitling something, almost every well-drafted estate plan includes something called a pour-over will alongside the revocable living trust.
A pour-over will? Okay, what does that do?
It acts like a safety net. It's usually a very simple will, and its main job is to say, basically, hey, any assets that I owned in my individual name at the time of my death that I somehow forgot or didn't manage to get into my trust while I was alive should be poured over into my trust now.
Okay, so the pour-over will acts like a final cleanup crew, catching any assets that were left out.
Precisely. It ensures that ultimately all your assets are distributed according to the single set of instructions you put in your trust. It maintains the integrity of your overall plan. However, and this is important, if that forgotten asset is significant, like that $500,000 account we mentioned, the pour-over will still has to be probated to legally get that asset moved into the trust. So while the trust is the best tool for avoiding probate altogether, the pour-over will is the essential backup to make sure your distribution plan holds up, even if it means a smaller, hopefully simpler probate might still be needed for those overlooked straggler assets. Hashtag 2.3 healthcare directives and durable power of attorney, pre-death clarity.
All right, so the will and trust primarily deal with distributing assets after death. But the next two documents are absolutely critical for handling decisions, financial and medical, while someone is still alive but unable to make decisions for themselves, incapacitated. The sources specifically mention healthcare directives, but I think we absolutely need to discuss the vital, complementary role of the durable power of attorney as well.
Yes, these are the indispensable living documents, the pre-death planning tools. Healthcare directives, they focus solely on medical decisions. Typically, they have two main parts. First is the living will. This outlines your specific wishes about life-prolonging treatments. Things like ventilators, feeding tubes in very specific situations, like if you're terminally ill with no hope of recovery or in a persistent vegetative state. The second part is usually called the designation of healthcare surrogate, or sometimes a healthcare power of attorney. This is where you name the specific person, your agent, who is legally authorized to make medical decisions for you if and when you can't make them yourself. And their importance in reducing stress is just enormous. Think about it. They remove that terrible burden of guesswork from your family members during what's already an incredibly emotional and chaotic medical crisis. You're providing clear instructions, but And this is key, these directives. They only cover medical issues. They give your agent zero authority over your finances.
Right. And that's the gap the durable power of attorney, the DPOA, is designed to fill.
Exactly. The DPOA is arguably the single most critical document for protecting yourself financially against incapacity while you are alive. It's where you name an agent, sometimes called an attorney, in fact, who can step in and manage your financial life the moment you become unable to do it yourself. Pay the bills, access bank accounts, file taxes, manage investments, even sell property if necessary. And it's called durable because, crucially, it remains legally effective even after you become incapacitated. A non-durable power of attorney would actually cease to be valid at the point of incapacity, making it useless when you need it most.
Okay, so it bridges that gap.
It completely bridges it. Now, think about what happens without a DPOA. If you suddenly become incapacitated, maybe a serious stroke, a bad accident, and you can't manage your own affairs, your family's only legal way to get access to your funds, even just to pay your mortgage or your medical bills, is to go to court and petition for a formal guardianship. In some places, it's called a conservatorship.
And a guardianship hearing.
Yeah.
That sounds exactly like the kind of court process we've been saying we want to avoid.
It's precisely what you want to avoid. It's another potentially costly, definitely lengthy, and very public court proceeding. It often involves judges, lawyers, sometimes expensive psychological evaluations to prove incapacity, all just to get the legal authority to pay your own bills with your own money. The durable power of attorney is the simple, private, relatively inexpensive document that completely bypasses the need for that court-supervised guardianship. It dramatically reduces the financial and administrative burden on your family during what is already likely a horrific time. So by having these 4 pieces documented, the will, the trust, and making sure it's funded, the healthcare directives, and the DPOA, you've essentially built a comprehensive fortress around yourself and your assets, both during life and after death.
Okay, so we've built this conceptual fortress with those 4 key documents. Now let's take that fortress and see how it holds up, how we need to adapt it specifically for the unique environment of the Sunshine State. This is where, as our sources suggest, it gets really interesting because now we have to explore those distinct advantages Florida offers, but more critically, the complex legal hurdles that come with being a resident or owning property there. As we kind of established earlier, just generic planning, it simply doesn't cut it in Florida.
Yeah, specialized planning isn't just advisable, it's basically mandatory if you want certainty. Because Florida's legal landscape, particularly around property, is fundamentally different from most other states. It definitely attracts wealth, but that wealth becomes really exposed if your planning documents aren't specifically tailored to Florida's unique statutes. Hashtag 3.1 the income tax advantage and its planning implications. Let's start with the big magnet, the major attraction. Florida has no state income tax, 0. Plus, no state inheritance tax and no state estate tax either. This is a massive advantage, especially if you compare it to high-tax states like, say, New York or California, where the combined state and maybe local income tax burden can be really significant, even oppressive for high earners.
Right, that creates a huge financial incentive, doesn't it? For wealthier individuals, retirees, business owners, to officially establish their primary residency, their domicile in Florida.
It absolutely does. But here's the critical planning implication that often gets overlooked, or maybe isn't emphasized enough. Because this tax advantage tends to attract individuals who, by definition, often have higher net worths, more complex asset structures, maybe assets scattered across multiple states. Well, all those existing legal complexities within Florida, especially the tricky rules around property ownership, residency status, and particularly homestead, they become dramatically amplified. The stakes get much higher. Think of it this way. If a legal mistake in planning leads to, say, a $100,000 problem for a modest estate, that's obviously bad. But if that same type of mistake happens with a $20 million estate that was attracted to Florida partly because of the tax savings, well, now that $100,000 mistake could easily become a multi-million-dollar catastrophe.
That makes sense. The scale is different.
Exactly. And furthermore, those wonderful benefits of avoiding Florida state income tax during your lifetime, they're only fully realized if the estate can later be transferred efficiently and smoothly after death. If a lack of proper Florida-specific planning leads to huge probate costs, or maybe having to open ancillary probates in 3 other states, plus litigation over how the homestead property should pass, the family can easily end up bleeding out much of the wealth that Florida's tax laws help them accumulate or preserve in the first place. There's a direct correlation. The larger and more complex the estate potentially becomes due to Florida's tax advantages, the higher the stakes become for getting the intricate details of Florida estate law absolutely right. Hashtag 3.2, the dual nature of homestead laws.
Okay, let's talk about probably the most famous or maybe infamous and definitely frequently misunderstood aspect of Florida estate planning. The homestead law. We know its main purpose, its core feature, is creditor protection for your primary residence. Can you explain the scope of that protection? And then, crucially, why does that protection come with these seemingly severe restrictions on how you can actually transfer the property?
The protection itself is incredibly powerful. Florida's constitutional homestead exemption makes your primary residence up to a half-acre within a municipality or 160 acres outside virtually immune from forced sale by most general creditors. Think credit card debt, business judgments, personal loans. Most creditors simply can't force the sale of your protected homestead to satisfy their claims. This is a huge asset protection benefit, and it's another reason people, especially those in professions with high liability risk or those carrying significant debt, are drawn to establishing residency in Florida.
Okay, powerful protection.
Very powerful. However, as the sources really emphasize, there's a flip side. This protection comes at the cost of imposing significant restrictions on your options for transferring the property, meaning how you can give it away either during your lifetime or, more commonly, after you die. And these restrictions become particularly strict if, at the time of your death, you are survived by either a spouse or any minor children.
Okay, restrictions on transfer if there's a spouse or minor kids. This is the part that can unexpectedly override what someone clearly stated they wanted in their will or trust. I need you to really break this down. How exactly can this homestead restriction just nullify a clear instruction, say, in a will?
This is the absolute classic pitfall, and yes, it happens when the deceased homeowner, the decedent, is survived by a spouse or minor children. Florida law basically imposes what are called forced share restrictions, specifically designed to protect the family unit, the surviving spouse, and young kids. And these statutory restrictions supersede whatever the decedent might have written in their will regarding the homestead property.
Supersede the will. Wow.
Yes. So let's take an example. Let's say a married person dies, owning their Florida homestead home in just their name. They are survived by their spouse, but they have no minor children. Maybe their will clearly states, I leave my entire interest in my home to my beloved alma mater or to my favorite nephew. Florida law says no. Regardless of what the will says, the surviving spouse automatically gets certain rights dictated by statute. They have two main options. Option 1, they can take what's called a life estate in the home. This means they have the absolute irrevocable right to live in and use that home for the rest of their life. They have to pay the basic expenses like taxes and insurance, but they can't be kicked out. Then, only after the surviving spouse passes away does the ownership interest, called the remainder interest, pass to whoever the decedent's lineal descendants were, their children or grandchildren typically, not necessarily who the will named. Option 2, instead of the life estate, the surviving spouse can formally elect within a specific time frame to take a 50% ownership interest in the home as a tenant in common. The other 50% interest would then immediately pass to the decedent's lineal descendants.
Wait, let me process that. So even if the will explicitly said, I leave my home, my biggest asset, 100% to Charity X, if that person was married when they died and owned the home individually, that entire provision in the will regarding the home is just ignored, rendered null and void by state law. The spouse still gets either that life estate or the option for 50% ownership.
Absolutely nullified regarding the transfer of the full ownership, the fee simple title. The law's mandate to protect the surviving spouse completely overrides the decedent's documented wishes in the will for that specific asset. And it gets even more restrictive if the decedent is survived by both a spouse and minor children. In that specific situation, the law dictates that the surviving spouse automatically receives the homestead property in fee simple, meaning 100% outright ownership. The minor children essentially get protected by ensuring the spouse gets the house. Again, the will cannot change this outcome. This becomes especially problematic, as you can imagine, in blended family situations. Maybe the decedent really intended for the home, which they owned before the current marriage, to pass directly to their adult children from a previous marriage. Florida homestead law might prevent that entirely if there's a surviving spouse.
That is genuinely alarming. It means someone could spend time and money carefully drafting a will, thinking they've clearly laid out their wishes, only to have this specific Florida statute, which they probably didn't even know existed, completely blow up their plan for what might be their single largest asset. So how do experienced Florida planners navigate this? How do you plan around these restrictions?
Planning effectively around homestead restrictions absolutely requires specialized techniques, tailored to Florida law. It's not something a generic plan will address. For instance, if you want the home to go into your revocable living trust to avoid probate and control its ultimate distribution, you need to make sure the property is correctly titled in the name of the trust. And critically, if you're married, your spouse usually needs to formally sign off on this, either through specific language in the deed transferring the property to the trust, or sometimes through a spousal waiver in a prenuptial or postnuptial agreement, confirming they understand and agree to waive their potential homestead rights upon your death.
Okay, so spousal consent is key.
Very often, yes. Another very common and powerful technique used specifically in Florida to bypass probate on the homestead property while still keeping the valuable creditor protection during your lifetime is using an enhanced life estate deed, which is often nicknamed a ladybird deed.
A ladybird deed. Okay, what's special about that?
An enhanced life estate deed, or ladybird deed, is unique. It allows the property owner, the grantor, to retain full control and ownership rights over the property during their lifetime. They still own it, they can sell it, they can mortgage it, they can change their mind and change the beneficiaries. They retain all the sticks in the bundle of property rights except the right to devise it by will. But the deed also names specific beneficiaries who will automatically inherit the property immediately upon the owner's death outside of the probate process. Because the owner technically only retained a life estate, albeit an enhanced one with lots of control, the property transfer upon death happens automatically by operation of the deed itself, bypassing probate. And importantly, because the transfer happens this way, it often avoids many of the tricky homestead transfer restrictions that apply to wills or intestacy. It's a really powerful Florida-specific tool, but it absolutely has to be drafted correctly and put in place proactively while the owner is alive and has capacity. Hashtag 3.3, the multi-state asset headache.
Okay, let's pivot now to the final major headache that our source materials really highlight. This seems especially relevant given Florida's popularity as a destination for retirees, snowbirds, and people with vacation homes. The problem of owning real estate, owning property in multiple states. This has got to be incredibly common, right? And the sources suggest that failing to plan specifically for this just multiplies the cost and complexity exponentially.
Oh, it's the classic multi-jurisdictional nightmare scenario. The underlying legal principle here is actually pretty simple. Real property, meaning land, and any buildings fixed to it, is always governed by the laws of the state where that property is physically located. Always. So, let's say you're a permanent Florida resident, your main home is here, your domicile is Florida, but maybe you also own a ski condo out in Colorado and perhaps a little lake house up in Maine that's been in the family. Your Florida will, and the main probate process that happens in Florida based on your residency, only has legal authority over the assets that are considered legally domiciled in Florida, plus your personal property wherever it is. It generally has no direct authority over that real estate sitting in Colorado or Maine.
Okay, so the Florida court can't just order the Colorado condo to be transferred.
Not directly. The consequence of actually just means supplementary or secondary. When you pass away as a Florida resident owning property elsewhere, your personal representative, the executor, has to first open the main or domiciliary probate here in Florida. Then they have to go and hire a separate lawyer who is licensed to practice in Colorado. They have to pay separate court filing fees in Colorado, and they have to open a completely distinct additional probate proceeding in Colorado just to deal with that condo. And then they have to do the exact same thing again in Maine for the lake house, hire a Maine lawyer, pay Maine court fees, open a Maine ancillary probate.
Wait a minute. So instead of dealing with one already complex court process, the family and the executor suddenly find themselves managing potentially 2, 3, or even 4 separate concurrent legal proceedings in different states, all requiring them to comply with different state laws, different procedures, different deadlines.
That is the expert synthesis of the nightmare, yes. You absolutely multiply the cost. You're paying hourly fees for attorneys in multiple states. And remember, those attorneys have to be licensed specifically in that state. You multiply the administrative burden, separate inventories, separate accounting, separate court filings, and you dramatically multiply the time it takes to settle the entire estate because the final distribution of assets often can't happen until all the probate processes, including all the ancillary ones, are fully concluded. Each state's process moves at its own pace, potentially holding everything up. Ancillary probate is precisely the kind of costly, time-consuming mess that efficient estate planning is specifically designed to prevent.
Okay, so how do you prevent it? What's the solution?
This is where that revocable living trust we talked about earlier really shines. It's often the perfect solution, the panacea, for this multi-state real estate headache. Remember how we said the trust, as a legal entity, takes ownership of the assets? Well, if you properly transfer the title of your Colorado condo and your Maine lake house into the name of your Florida-based revocable living trust while you're alive.
Then the trust owns them, not you individually.
Exactly. So when you pass away, those properties are not part of your individual estate subject to probate in Colorado or Maine. They are owned by the trust. The distribution of those properties is now governed by the terms of your trust agreement, which is typically governed by Florida law if you set it up as a Florida trust. In most cases, your successor trustee, the person you name to take over, can then simply work with local title companies or attorneys in Colorado and Maine to record new deeds, transferring the properties directly from the trust to the beneficiaries you named in the trust. Usually, no formal court-supervised ancillary probate proceeding is required in those other states at all.
Wow. So failing to plan properly in Florida can hit you with a double whammy. You might get tripped up by Florida's unique homestead rules for your Florida home, and you can trigger these expensive parallel probate processes in every other state where you happen to own property. But the trust, if it's set up and, crucially, funded correctly with those out-of-state properties, can potentially solve both problems.
It can be a very elegant solution to both the probate avoidance issue generally and the specific multi-state ancillary probate problem, yes. Provided, as you rightly emphasized, it is properly funded. That's always the key.
Okay, let's pull back a bit now and look at the bigger picture, the overall strategy. Our sources really stress this point. Estate planning can't just be this separate thing you do, like checking off a box on a random to-do list. It absolutely must be integrated, woven into your overall financial strategies. Why does that holistic approach matter so much, particularly maybe in terms of avoiding potentially massive, unexpected tax hits down the road?
Integration is absolutely essential because if you plan in silos, if your estate plan over here doesn't talk to your retirement plan over there or your life insurance over here, you risk creating catastrophic, completely contradictory outcomes. You know, most people, when they think estate planning, their mind immediately goes to the will and maybe the trust. But the reality is, for many people, a huge chunk of their total wealth, sometimes 60%, maybe even more, actually transfers completely outside of the will and trust. How? It transfers through specific contractual arrangements, primarily through beneficiary designation forms. Think about your 401ks, your IRAs, your life insurance policies, maybe annuities. Each of those has a form where you name who gets the money when you die.
Right, those beneficiary forms.
Exactly. And your overall financial strategies, especially the ones focused on tax deferral, like maximizing retirement accounts, rely heavily on getting those beneficiary designations right. Your estate plan, the will, the trust has to be perfectly aligned with those designations. If they contradict each other, you get chaos and often huge, unnecessary tax bills for your heirs.
Okay, can you give us a concrete example of how that kind of contradiction could lead to a real catastrophe? Like, what happens if someone's will says one thing, but the beneficiary form on their giant IRA says something totally different?
The contract wins, period. That beneficiary designation form you filled out on file with the custodian of the IRA or the 401k or the insurance company, legally, it is supreme. It completely overrides whatever instructions might be in your will or even your trust regarding that specific account. So, classic example. Your will clearly states, I leave my entire estate, everything I own, to my current spouse. Makes sense. But maybe you set up your large 401k 20 years ago during your first marriage, and you named your first spouse as the beneficiary back then, and you just forgot to update it after your divorce and remarriage.
Oh boy.
Yeah. When you die, that entire 401k balance, regardless of what your will says, is legally obligated to be paid out to your ex-spouse. Your current spouse gets nothing from that account. Your will is completely irrelevant to that specific asset because the contract the beneficiary form dictates the outcome.
That's rough. Misdirection of assets.
It is. But the financial implications, the integration piece, they actually go much deeper than just sending the money to the wrong person. They have profound tax consequences. Let's say, for instance, someone makes the mistake of naming my estate as the beneficiary of their traditional IRA. Or maybe they name their trust, but the trust document wasn't drafted correctly with specific IRS provisions needed to qualify as a see-through trust. In those scenarios, the entire tax-deferred status of that IRA could be lost immediately upon death. This often forces the distribution of the entire account balance much faster than anticipated, sometimes within just 5 years, if the estate is the beneficiary, and makes the whole amount subject to income tax right away. Depending on the size of the IRA and the beneficiary's other income, this could push the inherited funds into the highest possible marginal income tax brackets, essentially turning what should have been a valuable tax-advantaged inheritance into a sudden, massive tax bomb for the family.
Wow. So that mistake, that lack of integration between the estate plan document, like the trust, and the beneficiary designation, it basically destroys the entire benefit of decades of tax-deferred savings.
That's right.
It makes the assets way less valuable for the family when they actually receive them.
It can completely eradicate the opportunity for favorable tax treatment. You know, before the Secure Act changed the rules a few years ago, beneficiaries could often stretch the distributions from an inherited IRA over their entire lifetime, minimizing the annual tax hit. Now, for most non-spouse beneficiaries, that stretch is gone. They generally have to empty the entire inherited account within 10 years after the owner's death. But even to get the benefit of that 10-year payout period, you still usually need to name a living individual or a properly structured see-through trust as the beneficiary. Making a simple mistake, like just naming my estate, often destroys even that 10-year window, forcing a much faster payout and potentially much higher taxes. Proper integration ensures you preserve liquidity, you avoid triggering unnecessary capital gains or income taxes, and you keep the family as secure as possible by maximizing those tax deferral benefits you worked so hard to build up while you were alive.
Okay, that really drives home the need for that holistic view. Now let's talk about timing. Our source material mentioned that, maybe a Estate Planning Awareness Week has technically passed, but it stressed that the urgency remains.
Right.
We've clearly established the high costs of doing nothing, the specific complexities of Florida law. Let's focus on the practical reality here. Why can't this just wait? Why not put it off until, say, the end of the year or when things slow down?
The urgency, fundamentally, it's rooted in the simple, unavoidable fact that these planning documents, the will, the trust, the DPOA, the healthcare directives, they are only necessary, only effective when the person who created them, the planner, is no longer available to act for themselves, either due to sudden incapacitation or death. And those events are, by their very nature, unpredictable. Once you lose mental capacity or once you pass away, the window to take control to put your wishes down legally, it's slammed shut immediately and irrevocably.
Right. You can't sign documents if you're incapacitated.
Exactly. And remember that 76% statistic. That means right now, today, 3/4 of Americans are leaving their assets, their family's future security, completely subject to those rigid, impersonal state laws we discussed. They're vulnerable to family disputes. They're susceptible to the guaranteed cost and time delays of probate, and potentially ancillary probate if they own property elsewhere. Every single day that goes by without a plan in place is another day you're running that risk. Furthermore, capacity isn't always lost gradually. It can vanish in an instant, a car accident, a sudden medical event like a stroke or aneurysm. If you lose capacity before you sign that critical, durable power of attorney, your family's only option to manage your finances is that expensive, public, time-consuming guardianship hearing in court that we were trying so hard to avoid with good planning.
So given all the complexity we've uncovered, especially in Florida with the homestead traps, the multi-state property issues, the real risk of needing a guardianship, all those tax pitfalls, from poor integration waiting, doesn't just maintain the current risk, it actually compounds the potential negative consequences exponentially, doesn't it?
It absolutely does. And that really brings us to the most powerful, maybe the simplest call to action when it comes to timing. You've probably heard the saying, but it's timeless because it perfectly captures the reality of risk management when it comes to planning for the inevitable. The absolute best time to start your estate plan. It was yesterday. You can't get that time back. The opportunity, it might have already passed for some. But if you didn't start yesterday, the second best time is right now, today. Particularly given the specialized, heightened complexities we see in Florida, where the financial cost of procrastination is demonstrably, measurably greater than it might be in jurisdictions with simpler laws. The risk of waiting is just too high. You're either in control, actively using the legal system and these planning tools to protect your family and your wealth according to your wishes, or you're passively remaining part of that 76% who have effectively handed control over to the court system, basically guaranteeing costs, delay, public exposure, and potential conflict. That window for taking control, it's only open while you have the mental capacity to understand and act and the ability to find qualified, specialized counsel to help you navigate it correctly. Waiting is a gamble you can't afford to lose. Hashtag Shacked Outro summary and final thought.
Wow. This has been an incredibly crucial and really detailed deep dive into a subject that, as we've seen, far too many people push off. Let's quickly recap the absolute key takeaways for you, the listener, just to make sure this knowledge feels immediately actionable. First, remember that shocking reality. 76% of American families are currently leaving their financial future essentially up to chance. Doing nothing guarantees the state steps in. It guarantees significant costs, potentially up to 7% or more of your gross estate, just vanishing into probate fees, and it invites devastating family disputes. And in Florida, this often gets compounded by the requirements of that more complex formal administration in probate court.
Second takeaway, securing your future really boils down to executing 4 essential documents as a baseline. You need the will, primarily for distributing probate assets, but critically for nominating guardians for minors. You need the revocable living trust, and you need to fund it, making it the key tool to avoid probate, ideally backed up by that pour-over will safety net. And crucially, you need the living documents, the durable power of attorney to avoid the nightmare of a pre-death guardianship hearing for financial matters, and the healthcare directives, living will and surrogate designation, to provide essential clarity for medical decisions.
And third, absolutely critical. If you have any connection to Florida, you live here, you own property here, you're thinking of moving here, your planning must be specialized. Yes, the no-state income tax is a huge advantage that attracts wealth, but the complexities are real. Specifically, you have to navigate the dual nature of the homestead laws, which impose those transfer restrictions that can actually override your will. And you have to address the headache of owning multi-state assets to avoid triggering those costly ancillary probate proceedings elsewhere. This demands integrated planning right now, likely using Florida-specific tools like that Lady Bird deed or a meticulously funded trust, along with careful attention to spousal rights.
Yeah, and if we really want to connect all this technical analysis back to a practical application point for you, the individual listener, here's maybe a final thought to really mull over based on what we've discussed. We've established that probably the biggest unique risks in Florida often revolve around that homestead property and owning assets in other states. And maybe the biggest risk in integrating your overall financial life is getting those beneficiary designations wrong. So consider your own situation right now. Do you know for certain how your primary Florida residence is currently titled? Would it pass subject to that surviving spouse's life estate or 50% election if something happened today? Or is it already structured, maybe with a Lady Bird deed or held in your trust, specifically to bypass probate and those restrictions? If you own property outside of Florida, have you actually taken the step to fund that property into your trust to avoid ancillary probate later? Have you recently reviewed all the beneficiary designations on your IRAs, 401ks, and life insurance to ensure they align perfectly with your current wishes and your overall estate plan? If the answer to any of those specific questions is I don't know, or I'm not sure, or even I don't think so, well, that uncertainty right there is your most immediate, most urgent starting point for taking action.
That's a really powerful way to encapsulate why this discussion is so critical and why getting into the details, getting that integrated approach truly matters. Thank you for diving deep with us today into the mechanics of estate planning and specifically navigating the complex legal landscape of Florida. Please don't let your financial security, your family's future, be part of that 76% statistic. Get informed, take control, and protect what you've built. Start the process now. We'll see you next time on The Deep Dive.